And so we are calling this presentation the Paid Family and Medical Leave Act 2.0, because this is generation 2, and that we're in the second year of the Paid Family and Medical Leave Act being applicable to your workers. And also, I wanted to just focus on some selected topics based on questions that I'm getting from my clients. At this point, we're, I think, all familiar with the basics. So this presentation is not comprehensive. We're just focusing on some specific questions that have been coming up over the course of the past year or so. So PFML eligibility applies not just to employees, but also to independent contractors. And this is the case when your workplace is made up of more than 50% 1099 miscellaneous contractors as workers. Services must be performed by the individual. The individual must perform the services in Massachusetts, and the individual must live in Massachusetts. Similarly, the PFML applies to former employees in some cases. Former employees can be eligible if they've worked for you within the past 26 weeks, if they're currently unemployed, and if they're unable to perform functions of their most recent job or suitable employment because of the basis of their need for the family or medical leave. Next slide, please. Another thing that comes up a lot, and my clients have questions about the overlapping of FMLA and PFML. As you all probably know, they run concurrently. Employees who take PFML leave while eligible for FMLA leave may subsequently take FMLA leave during the same benefit year, but according to the PFML, only up to the combined maximum leave time allowed under the PFML, which means that between PFML and FMLA leave, they'd only be able to take 26 weeks total. Frankly, I'll be interested to see how this plays out, because to my mind, it's not clear how the PFML can govern eligibility for FMLA leave. Definition of family members is different between the FMLA and the PFML. FMLA is just spouse, son, daughter, parent as far as family leave. PFML also includes domestic partner, grandchildren, grandparent, and siblings. And interestingly, the PFML uses the term child, not just son or daughter, which is obviously consistent with the times we're living in and the fact that this is a new law. PFML benefit year. People ask me about this a lot. It starts on the Sunday preceding the first day of leave. As you know, the FMLA benefit year may be calculated in several ways. We recommend to our clients that they have them run the same way, so that your FMLA and PFML will start at the same time and run going forward from the first day of leave. Next slide, please. Okay, domestic partners, who qualifies as a domestic partner. I won't go over this slide in detail. You have it here, and everyone will get a copy of the slides after our presentation. But I wanted to point out something I noticed that's interesting here, which is there's nothing about it necessarily being a romantic relationship with a domestic partner. It has more to do with dependence or interdependence, particularly financially and relating to family responsibilities. Next slide. Paid time off. This is an issue that comes up all the time. So if you're receiving PTO, if your employee is receiving PTO for a qualified reason under the PFML, they cannot receive paid PFML benefits at the same time. So you cannot top off or supplement PFML benefits with PTO time. On the other hand, just want to remind you that the first week of PFML leave is unpaid under the PFML. So that would be an appropriate time for your employees to use accrued PTO while the first week of PFML is running, without in any way jeopardizing or reducing their PFML benefits starting the second week. PFML runs concurrently with PTO for a qualified reason, And it's important that you inform your employees so that they understand this, so that as they're taking their PTO, for example, in that first week, they know that the PFML is already running. Okay, next slide. This gets very hairy. When are PFML benefits reduced? When are they offset by other benefits that are being provided? The weekly PFML benefit amount is reduced by the amount of wages or wage replacement received from these sources. And I won't go through them because I want to zip through this so that we can stay on time. And then looking at the second section of the slide here, unless the aggregate amount that an employee would receive would exceed the employee's regular pay, the weekly benefit amount is not reduced by the following. So with respect to employees' short-term disability benefits, paid and family leave benefits that they may receive under an employer policy, wages from another employer if they have a second job or other covered business entity, or from self-employment, all of that is only going to reduce their PFML benefit if the total combined exceeds their regular weekly pay. Okay, next slide. And sometimes employers can be reimbursed for paying benefits. This is when you have not opted out because you have your own plan to replace PFML. It's rather when you are participating in the PFML program, but you make certain payments to your employees for PFML qualified reasons. So in this case, the employer does not have a private plan exemption, but makes payment to employees under paid temporary disability, your own family or medical leave policy. You may be able to receive reimbursement as long as the payments were made to the employee, again, for a qualifying reason. It's not PTO, and the reimbursement amount is limited to the amount that would have been paid to the employee under PFML. Next slide, please. With respect to retaliation, there is a 6-month presumption of retaliation. This is very important for employers to understand. Employers, of course, are prohibited from discriminating or retaliating against any eligible individual for exercising their rights under the PFML. Any negative change, this is something you must be very, very careful about. Any negative change in seniority, status, benefits, pay, other terms or conditions of employment that occur either during the leave or during the 6-month period following the leave, or the 6-month period following the employee's participation in any PFL proceedings, will be presumed to be retaliatory. Then the burden of proof will shift to you as the employer, and you are going to have to overcome this presumption by clear and convincing evidence that you would have independently decided to take the same exact action against this employee, regardless of their participation in PFML. So again, the presumption is overcome only by clear and convincing evidence that the employer had independent justification for taking action and would have taken the action in the same manner and at the same time the action was taken, regardless of the employee's exercise of their PFML rights. Next slide. Okay, so we're moving on to Gary Feldman, and he will